Good morning, everybody. I am back again, and I'm the host, Supreme Litigant. And I'd like to welcome all of y'all back to Smart Low TV. It's been a minute since I did a video for y'all. I've been doing lives so far. Before I begin, if you haven't already, you know the routine. Go ahead and pound that like button and that subscribe button. This video was made for information. From information provided to me from a subscriber on my channel, Mr. Michael Cummins. Thank you for this information, Michael, by the way. This is pretty good. I actually just got up this morning and just started looking at this stuff. So I've been looking at it for probably about 20 minutes. But so I want to talk about it. And Michael, if you watch the video, if you feel like I didn't touch on a topic in a video that you feel that needs to be talked about, just go ahead and comment it below, and I'll probably make another video. So let's just go ahead and jump right into it. So basically, this video, this website, it allows you to file complaints against police officers, prosecutors, and judges when they violate the Brady list. So let me go ahead. I know some of y'all probably don't know what this is, so I'm gonna go ahead and read some of it to you. The Brady rule, named after Brady versus Maryland, requires prosecutors to disclose material exculpatory evidence. If y'all don't know what exculpatory evidence is evidence that tends to show that you are not guilty. Any type of evidence that tends, in other words, any type of evidence that your attorney can use against the state to prove that you are not guilty. That is what exculpatory evidence is. But anyway, the Brady rule requires prosecutors to disclose materially. Sorry, y'all. Excuse me. I just woke up. Materially exculpatory evidence in the government's possession to the defense. A Brady material or issue a Brady material or evidence the prosecutor is required to disclose under this rule includes any evidence favorable to the accused, evidence that goes towards negating a defendant's guilt that would reduce a defendant's potential sentence, or evidence going to the credibility of a witness. So I want to talk about this. I want to also talk about this part right here. If I'm not mistaken, this is relating to Giglio, which is another Supreme Court case. But this is how you impeach the police officers right here, because it should be under every state's rules of evidence, and I know it's under the federal rules of evidence. I'm not sure which rule it is, but it's probably rule 440 something. But this is how you impeach the witness. That's what they're talking about right here. That's what they're talking about. But anyway, I'm gonna read a little bit more, and then that'll be it. If the prosecution does not disclose material exculpatory evidence under this rule, and prejudice has ensued, the evidence will be suppressed. That's your remedy when they violate due process, or that's your remedy. The evidence will be suppressed regardless of whether the prosecutor knew the evidence was in his or her possession, or whether or not the prosecutor intentionally or inadvertently withheld the evidence from the defense. Okay, that's just one. Let's go to Giglio. I want to read y'all some of these, the Giglio opinions. Let's go to this one right here. And this is a 10th Circuit case right here, but this rule generally applies in all federal courts. Mr. Gonzalez Montoya unsuccessfully sought a mistrial on the grounds that the government's violation of the disclosure rules of Giglio versus United States, blah, 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 deprived him of a fair trial. We review questions regarding the disclosure of exculpatory or impeachment evidence de novo. Impeachment, as well as exculpatory evidence, falls within the rule articulated in Brady versus Maryland, that suppression of material information favorable to the accused violates due process. In order to establish a Brady or Giglio violation, the defendant bears the burden of establishing one, that the prosecution suppressed the evidence, two, that the evidence was favorable to the accused, and three, that the evidence was material. So that's just something just to give you an idea of what I'm talking about. And there's another one up here. I think I'm going to read y'all some of this one too. This is a Seventh Circuit case. Under Brady versus Maryland, the government violates a criminal defendant's due process rights when it fails to disclose evidence favorable to the defendant and the material to guilt or punishment. Giglio extended that rule to impeachment evidence to inform, to information calling into the credibility of a witness. So where's that rule at? It should be in rule, I think it's rule 406 of the Federal Rules of Evidence. But anyway, the Federal Rules of Evidence is what dictates the admissibility of evidence in a case. And whatever your state is, it might be, let's say you're in the state of Georgia, it might say Georgia Rules of Evidence or something like that. Then those rules would dictate all of all of the admissibility of evidence in Georgia, so on and so forth. It doesn't matter. Let's go back here. Okay. Let's go here. I mean, this is just some basic information that y'all can just go and study and read for yourself. But I'm just bringing this to y'all's attention. This is what you use to file motions to suppress or to file a motion to vacate, a judgment because they violated due process or something like that. So exculpatory evidence is under Brady. Tends to show defendant is not guilty or deserves a lighter punishment. That's Brady. Impeachment evidence, Giglio. Admissible evidence which tends to show a state's witness should not be relied upon because they lie. So I would, just to give you an example, let's say, you go through discovery in a criminal case and you find some evidence that shows the state's key witness, which would be a police officer, has lied in a police report or in an affidavit to procreate these so-called criminal charges against you to induce a conviction, to sustain a conviction against you. You would bring that up. It's pretty easy. You would bring it up. You would get that evidence admitted into court. You'd argue your case, probably file a motion to suppress, a motion to vacate, dismiss for due process violations or something like that. You would simply state your facts in support of why this motion should be granted. And if you wanted to, you would supply the court with the relevant case law in support of those facts. It's the same shit, y'all. The same thing you do in a civil case, you do it in a criminal case. It's the same shit, y'all. The same exact thing. This is just something I downloaded just so y'all can just go and see for yourself. I'm not gonna scroll through all of this because I don't want to confuse nobody. But anyway, so let's say you wanted to file on this site, back to the website. So let's say you wanted to file a complaint against a police officer. So you would simply click this. All right, you would scroll down. These are all the categories right here of abuse, or whatever you wanted to file a complaint about a police officer. It should be a little longer than that. Yeah, this is a pretty decent list, So you would they ask you what type of complaint, which would be something like this right over here. So you would list the type of complaint, or if it's a law enforcement organization, whatever, officer's police name, date, time, location, statement, evidence, witnesses, contact information, and you hit submit. I really like this website. Thank you, Michael. I really like this website. Let's say if you wanted to do it against a prosecutor. So we'll hit this prosecutor. The prosecutor's role in our adversarial justice system to obtain convictions, regardless of a defendant's guilt or innocence, necessarily creates competitiveness in the terms of winning cases. But as stated by the Supreme Court, while he may strike hard blows, he is not at liberty. He is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. See what I'm saying? So, you would simply type a complaint, hit this, whatever, it would go down right here. There's the list. The list is also right here. The jurisdiction, prosecutor's office, prosecutor's name, date, time, statement, evidence, and then you would after you would go through all of this and list all of the information, you would just simply hit submit. Let's see. Okay. See, I didn't scroll down here, but it looks like they have different states on here too as well, which is pretty good. That's real good. So it's very detailed. It seems to be. Anyway, it seems to be very detailed, which is good. Let me go back. I think I'm gonna title this video the Giglio and Brady list. Or yeah, I think I'll do that. Or the Brady list and the Brady and Giglio list, something like that. It doesn't matter. But I just want y'all to understand it. So let's say if you wanted to file against a judge. Judicial officers have a significant level of power over the outcome of many matters and lives. The power is too often not overseen. And we must provide civilian oversight and accountability. These people do need to be held accountable. Like they really need to be held accountable. Because I don't know if any of y'all have ever read any cases involving judicial immunity, or they call it absolute immunity or judicial immunity. One of those two. Well, actually, they call them both of them. But anyway, if y'all have never read any of those types of cases, I advise y'all to read them, because when I tell y'all them motherfuckers have carte blanche to do damn near whatever they want, they have carte blanche to do damn near whatever they want. Let me go to this definition and show y'all what carte blanche is, because some of y'all don't know what it means. Complete freedom to act as one wishes or thinks best. I'm gonna give you the legal. I would say that is the actual definition, but let me see if the legal definition kind of words it different. Okay, yeah, so okay. It's a French term that means blank document. Carte blanche is commonly used in English to refer to a check that has been signed but does not have a dollar amount written in. Yeah, so you get what I'm saying. They have that type of authority with judicial immunity. Now, judicial immunity can be nullified by the people whenever the fuck the people decide to nullify it, because you can change, the people can change the Constitution whenever the fuck they want. They can do it right now if they want, because they sovereign. But anyway, you would identify the judge, name, court, blah blah blah. When did the misconduct occur? Select the type of misconduct the judge committed, so on and so forth. And also, some of your states, they may have administrative agencies over these courts, like a judicial review board or something like that, which is really an administrative agency. It functions in the nature of an administrative agency because it was created, in my opinion, by the legislature. So they're not courts, y'all. They're all of them are administrative agencies. All of them are administrative agencies. But let's not talk about that right now, because that's not the topic of this video. Let's see. Okay, yeah. So and here's it, like if you wanted to scroll through and read some of the stuff. These are for law police officers right here. So you would just simply click this. It would go up. I mean, it would load up a complaint that somebody filed. Let's see. I'll use this one just as an example, just to show y'all. So this is a citizen's report. Roland Police Department. I'm guessing who's the police officer? It must be this guy right here. Full-time police officer. Yeah, so it was the guy above. Anyway, these are the facts or whatever. Right here, there's a Facebook Live video in support of whatever happened to whoever wrote this. Here's a Facebook Live video in support of what they're doing. Or in other words, of their complaint, and so on and so forth. All this stuff is pretty easy to understand. This again, Michael, this is a pretty good website. Thank you. So let's go to, we'll just hit prosecutors. And right here, any prosecutor that fails or refuses to fully disclose all Brady Giglio material, in other words, exculpatory and impeachment evidence, including but not limited to records of police misconduct, public complaints, and use of force reports, is subject to rules of professional conduct. Yeah, they are. 3.8G, special responsibilities of the prosecutor. Violation of, was that rules of professional conduct? Yeah, G, may include an individual attorney while acting in the capacity of prosecutor being sanctioned up to and including disbarment. The obligations. Yeah, look, man, all of this is very, very good information. And I agree, with a lot of what's being said in here. But I hate to sound like a pessimist, and I'm not trying to discourage anybody from filing complaints against these people. Do that. Don't let them just do whatever the hell that they want. Don't let them do that. Okay. But I just want y'all to understand that when you do file these complaints against these people, um, their colleagues are very, very, very slow at sanctioning their friends, or so on and so forth. In other words, punishing them. Or like, let's say, for instance, if you file a criminal complaint against a police officer, yes, you can do that. And you file it with the prosecutor, you had your probable cause hearing and there. You probably won't even get a probable cause hearing, because once they find out that you filing criminal a criminal complaint against a police officer, they're gonna drag their feet, or they're gonna ignore you, or they're gonna say we're gonna have to investigate this, and we'll call you back or something like that. You'll probably never hear back from that. Just they do so much shit to just make you give up, or just to piss you off, But don't give up. So I'm just letting y'all know what you're getting yourself into. Also, I want to talk about just for a minute. What is it? Title 18, 240. I think it's 242. When is I think what is it? Conspiracy to violate rights or something like that. This is how it works, y'all. Just y'all know the same way I keep telling y'all to draft this 42 section 1983 complaint. When I tell y'all the facts really matter, it's the same damn thing with this with that title. Was it title 18 242? It's the same damn thing, except you're just using an affidavit. But in this affidavit, you're talking. Let's say if you want to procreate these so-called criminal charges against a police officer for assault and battery, then you only talk about facts that show this police officer assaulted and battered you. You don't talk about shit else. Those are the only facts that you list in that affidavit. You don't talk about nothing else. That's it. That's it. And it's just pretty. You would file that complaint with the with the United States attorney, whoever it is, and then it should just go from there. It should go for a magistrate. The magistrate should then look at that to determine if probable cause exists. If it does, the magistrate then should issue an arrest warrant, and so on. It's the same shit, y'all. It works the same way on the civil side, and it works the same way on the criminal side. It is the same exact shit. That's all it is, y'all. That's it. Don't let these people confuse y'all and overly. Sometimes they tend to make this shit to make y'all to make people think that it's more complicated than it is. It's not. It may just be worded where it is worded in another language to where you can't understand it, but it is very, very, very simple. It's very simple. Let's see. So we got a prosecutor. Let's see. Let's see. Here's one right here. Somebody says is it failure to disclose Brady Giglio material. So employer, Johnston County District Attorney. This is somewhere in Oklahoma. Let's see who did this one. Well, let's see if we can read it. Reporting authority. Okay, the complaint has been forwarded. So yeah, this is a PDF file, so you can go and read it. You know, let's see. Craig Ladd has not disclosed to defense counsel or defendants that his assistant district attorney, Fernell Smith, was named as a potential witness in an appeal, blah, 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 to answer for withholding of exculpatory evidence and destruction of evidence in a capital murder. Damn. See attached motion for evidentiary hearing, naming Fern Smith as an anticipated witness. See that? Yeah, I would definitely I would report his ass to the bar. And I wouldn't give up. And I would file some I'd probably file a motion to suppress any damn, but man, I would file so many damn motions against these people for that violation right there. You destroying evidence. That's obstruction of justice. So on and so forth. Anyway, but I just wanted to show y'all this. This is a pretty good website. The website is right here, giglio-bradylist.com. It's pretty good. Let me scroll through some more and just see, because I haven't clicked on anything else other than what I've already done. Let's see, the Supreme Court decision in Brady versus Maryland and subsequent rulings. Giglio et al. Have made it a duty of all law enforcement organizations. Notice when they say all all law enforcement organizations, they're not just talking about police. They mean the prosecutor. They mean these so-called judges who are sitting on these benches because they are members of the executive branch of government. They are agencies and they are adjudicating public policy. They are filing lawsuits against you. That is what they are doing. They're suing you for breaching policy, not law. Anyway, to provide to the prosecution any material that would have a reasonable possibility. Notice you see the word reasonable. Didn't I tell y'all about that damn word reasonable? If you watch my videos, you'll hear me say that word reasonable. They throw this damn word around every damn where. And I mean everywhere. To provide the prosecution, provide to the prosecution any material that would have a reasonable possibility of altering the results in a trial or could reasonably mitigate the sentencing of a defendant, and any material relevant to the credibility, notice I said relevant, there's another term, relevant to the credibility of witnesses, including but not limited to police officers, and so on and so forth. So on and so forth. I think I'm gonna do a video just to show y'all how to draft a motion instead of just telling you. You draft all motions the same exact way. You probably just bring it under a different rule, different set of facts, and then you would cite different case law in support of those facts on why your motion should be granted. It's the same shit. This shit is so simple, y'all. Anybody can do this shit. Anybody. So don't come your ass on my channel telling me that you can't do this, because yes, the fuck you can. Anybody can do this. All right, let me see if there's anything else I need to cover. Again, Michael, if there was something I missed in this video, just comment it below or something like that, and we can just go from there. I'm gonna try to do another live soon, and I want to have you as a host, and I'll just let you take over the floor. You can co-host, and I'll just let you answer questions that people may have, or we can just engage in back and forth dialogue or whatever. But I'm gonna go ahead, y'all, and I'm going to end this live. I hope this video helped y'all learn something. And I hope everybody enjoys their day. That will be the end of this video. The Supreme Litigant is out. Peace.